Yes, be ready. 3, 2, 1, start. I have heard learned counsel for the petitioners stop. None appeared on behalf of the respondents stop. Para. Perusal of the record shows that the petitioners also filed a revision before the Court of Additional Sessions Judge against the order of summoning, which stood dismissed on 7th February 1991. Stop. The contention of the learned counsel for the petitioners is that, in spite of their revision petition having been dismissed by the additional sessions judge, this court has wide and inherent powers to entertain this petition. Stop. No doubt, the High Court exercised these powers sparingly and cautiously. Stop. It is the duty of the High Court to prevent the abuse of miscarriage of justice or to correct the irregularities committed by the subordinate courts in judicial process. Stop. But I do not find that this is a case which calls for interference by this court, particularly in view of the allegations levelled against the petitioners by the complainant, which, if taken as a whole and read in its entirety, goes to show the commission of the offence for which the court has issued process against them to stand their trial. Stop. It is not for this court to evaluate the evidence or to see whether the allegations will ultimately end in conviction or not. Stop. Para. This is not a case where the complaint has been made to take revenge. Stop. Mere filing of a petition for divorce by husband does not show that any offence as alleged has not been committed by the accused. Stop. It is for the trial court to find out the truth after the complainant has led evidence and the accused has put up his defense if he so chooses. Stop. This court is not required to scuttle the case at its initial stage. Stop. In fact, the due process of law should be allowed to continue for the ends of justice. Stop. The recent trend is to delay the trial and to create obstacles in the smooth flow of the trial. Stop. Once the petitioners have availed the remedy of revision and without showing any miscarriage of justice, illegality, or misuse of judicial mechanism, they cannot be allowed to cut short the due process of law. Stop. The counsel for the petitioners has relied upon the case of Krishnan and Anothers versus Krishnavani and Anothers, JT 1997 (1 SC 657), which is of no help to them in due circumstances of the case. Stop. I find no merit in this petition and accordingly dismiss the same. Stop and over.